No matter what anybody tells you, the race for president isn't the only thing going on in America. I know a lot of people still talking about the debate, the pathetic debate. They'll talk to you about shutdown. And don't get me wrong, government shutdown's going to happen. There doesn't seem to be any way for this to go any other direction. You've got Kevin McCarthy who can't get his own Republicans together. You've got Kevin McCarthy who won't agree to what Chuck Schumer wants, a continuing resolution. You have Chuck Schumer, who leads the Democrats in the Senate, who won't agree to what Kevin McCarthy, the Speaker of the House, the leader of the Republicans, has going on. Shutdown is going to come. But then you've got the impeachment inquiry and the really strange response from the political left to say, there's nothing here. It's all made up. It's an inquiry. You expect them to have everything ready to go, but can't we argue that they have more regarding Hunter Biden and possibly Joe Biden than they ever had on Donald Trump? I think that's a clear gimme. And then there's the stories nobody's talking about, especially this one, which really does threaten free speech. Guys, welcome to the show, presented by Americans for Prosperity, americansforprosperity.org, economic liberty, free speech. The guy right there is William Jacobson, Cornell Law Professor. He is the mind behind legalinsurrection.com. I do want to get with you on a little bit of your thoughts and some of the things that happened with the impeachment inquiry, especially some stuff I want to share with you in a second. But you have a story over at legalinsurrection.com that I don't understand. This was the headline. I know you're laughing at me because I didn't get it. I'm telling you, I didn't understand the thing. I should have gone to law school. Here's how it reads. I'll even throw on the glasses for you. Georgia federal judge rules racially discriminatory contracting is speech and expression protected by the First Amendment. Emergency appeal filed. You want to take it very slow and walk that through with me, please?
I'll take it very slowly, but it is ending up in a very bizarre situation. I'll give you the end result before I get to the beginning. And the end result is, if this judge's ruling is held up, which is now supported by various civil rights groups, it could be the end of anti-discrimination statutes in the US. So the roles are reversed. The people who are supposedly for civil rights are arguing a position in a case which could end up destroying their entire regime of anti-discrimination laws. Stepping back to the beginning, Ed Blum is somebody who was behind the Harvard lawsuit on affirmative action, and his group there was Students for Fair Admissions. He formed another group, Americans for Equal Opportunity or something like that. And they sued an investment fund in Georgia because that investment fund had a special grant program which was only open to Black women. And the argument in that case in Northern District of Georgia is that that violates 42 USC 1981, which was a post-Civil War statute to protect contracting, essentially to give freed slaves the full right of contracting that white people had. And it basically says, I'm going to paraphrase because I don't have it in front of me, that everybody is entitled to equal contracting rights in the country.
And when we say contracting, we're talking about the ability to enter into contract, to have the opportunity to get a deal. And that would that apply specifically to the federal government or state governments and not to private citizens?
No, that applies. There's no such limitation. So they did not bring that lawsuit under the Equal Protection Clause of the 14th Amendment, which was what the Harvard UNC cases were, because arguably this investment fund in Georgia would not be subject to those constitutional limitations as a private entity. I'm not sure why they didn't sue under any other anti-discrimination statutes. That was their decision, but they sued under this specific one. I think it was the Civil Rights Act of 1866. I think I have the year right. Maybe it was 1868. And that's what they sued under, a single count that this grant program, which discriminated on the basis of race, was unlawful under that statute because it deprived people other than Black women, which would include Asians, Hispanics, whites, arguably Black men, deprive them of their right to fair treatment and equal treatment in contracting. So that is the case. It was something of a rally around effect. Al Sharpton, Ben Crump, the usual suspects rallied around this investment fund. And the investment fund is run by Black women. Okay. And they then created a grant program limited to Black women. And so they sued. And the judge ruled earlier this week that that grant program was okay because by limiting the grant, which would be a contract, they'd have to enter into a contract with the grantee who would agree to abide by the grant terms, that by doing that, they were expressing a viewpoint that Black women have been excluded from the investment field. And this is a way of them expressing their viewpoint, was this grant program. And that is protected, the judge said, under the First Amendment as free speech and free expression.
So now it gets confusing, because when I look at it, I say to myself, if I were to offer up, let's call it a scholarship, I'm Jewish. I know you are. If I were to offer up a scholarship to Jewish students, I can do that. I could say this is for Jewish students. How is that a problem regarding free speech?
Well, I'd have to look into that, whether you could in fact limit it, but that's not this case. The case in Georgia is race, and race is clearly covered by that statute. I don't know if religion would be covered. I'd have to look at it. But could you offer a scholarship only? Well, a scholarship, there would be a contract. Could you offer a contract solely to whites? I think Ben Crump and Al Sharpton would be the first to say, no, you can't. And they probably would cite the same provision that the plaintiff in the Georgia case has cited. It says everybody needs to be treated equally with regard. You cannot discriminate on the basis of race with regard to contracting.
So now we ask ourselves, what did this judge say? Talking to William Jacobson, a Cornell Law Professor, legalinsurrection.com. What did this judge say in the case that has you particularly bothered about this ruling?
Well, what the judge said is that this discriminatory contracting was a way of expressing their viewpoint. But that's never been the case with anti-discrimination laws. And that's why this poses such a threat, that you can express a discriminatory viewpoint. You can do many things. You can hold it in your head, but you can't act upon it for anything that's covered by the statute. So it's never been the case that conduct would be deemed to be pure speech. And this is to be distinguished from like the Baker case and the website designer case in the Supreme Court, where the argument was that it was pure speech, it was pure expression, that was writing a message on a cake or writing a message on a website was not conduct, it was pure speech. And I think the court characterized it that way. And so that's not this case. This is a contract which the judge says maybe has some message attached to it, but it's still conduct. And if it is the case that discriminatory conduct, refusing to hire somebody, refusing to promote somebody, refusing to extend contracts to somebody, if that, as long as there's some viewpoint you have, is now lawful, that the First Amendment trumps all of this, that's going to be devastating to all the statutes that have been passed since the Civil Rights Act of 1866.
So your argument is that this win that people like Ben Crump are celebrating is actually the thing that will do in as radically problematic all the things they say that they're fighting for.
Sure. I mean, you could imagine somebody who says, well, we're going to make the bathrooms in our establishment only available to whites because we want to express the viewpoint that whites need better access to bathrooms. I mean, that's essentially what the judge, under the judge's analysis, that would not violate the Public Accommodations Law, would not violate the Civil Rights Act, would not violate the contracting rights. I mean, it would not violate anything because it's a viewpoint. And the Supreme Court has never gone there. The Supreme Court has never said that conduct, discriminatory conduct, is protected speech. The Supreme Court has said speech is protected speech. You can stand on the corner and say whatever you want to say, but you can't do the conduct. And the mere fact that the conduct may be to send a message, to send a viewpoint, is not enough. And the Supreme Court has always, as the plaintiff said in their brief to the 11th Circuit, because they're seeking an emergency appeal, the Supreme Court has been very careful never to go there. But this judge went there. And I don't think the judge, I don't know the judge. I wasn't at the argument, although I did read the transcript and I read the opinion. I don't think the judge maybe really wants this as the result. I don't think this is a judge who woke up that morning and say, how can I destroy all the anti-discrimination laws? I don't think that's likely the case, but that's the result of this. It creates an absurd result. And so what the plaintiffs have done, they, within 6 minutes, I think it was, filed an appeal. So the way this went down procedurally, there was a verbal ruling from the bench. There were all sorts of news reports that people were celebrating. Oh, the judge turned down, the challenge to the Black women's scholarship. Look, Ed Blum lost again. We're so happy he lost, because they're angry with him over the Harvard case. But there was no real reporting on what the basis for the judge's ruling is. So at Equal Protection Project, equalprotect.org, which is our project that follows these things, we ordered the transcript. We contacted the court reporter, because the transcripts are not generally available for 90 days unless you buy it from the court reporter. That's right. Pretty standard at every court around the country. So we purchased it and I'm reading it. And then we got to the punchline where he said basically what I said. I said, wait a second, this is crazy. How can that be? Did they understand what this is going to mean? But we didn't write it up. This is only 2 days ago. We didn't write it up immediately because he said at the end, and I'm going to issue a formal written order and opinion. I said, let me wait to see. I mean, surely when he's writing this out, he's going to realize that what he said from the bench really doesn't make a lot of sense. And the written order and opinion is basically what he said from the bench. And as I've summarized here and paraphrased here, I haven't quoted him directly, but I've paraphrased him, that basically this Black woman only grant program, while it may be a contract and it may be subject to Section 1981, is still protected speech. And then he cites the recent Supreme Court ruling involving the website designer, but they're two very different cases.
Let me move you out of this. And for anybody who wants to see this, head on over to legalinsurrection.com. There is the headline. Georgia federal judge rules racially discriminatory contracting is speech and expression protected by the First Amendment. Sometimes you get what you wish for and things become very bad. I want to move you on to this impeachment inquiry, talking to William Jacobson, Cornell Law Professor, the mind behind legalinsurrection.com. It was on this show, I think, on one of the live streams, where you discussed the fact that an impeachment inquiry should happen. You were the first person I heard discuss it. I credit the entire impeachment inquiry to you being on this show, having this conversation with me, sir.
Well, of course, it never would have happened without me being on your show.
This is fact, and you can quote it. It's done. It's said. It must be true. I want to share with you a couple of things that happened. One, during the impeachment inquiry with Jonathan Turley, George Washington law, and then a couple of statements that came after. This was a question that was asked by Congressman, a Democrat, a part of the Progressive Caucus, Ro Khanna, out of California. Listen.
Can you explain to the committee and the country why you believe that the current evidence does not support the articles of impeachment today?
Well, at the moment, these are allegations, and there is some credible evidence there that is the basis of the allegations.
But I understand that, and I'm not questioning that. I'm questioning what you don't think today, if you were going to vote, if this was the case, you would vote no, correct?
On this evidence, certainly, because the inquiry...
Okay, and my question is, if someone said to you, okay, Mr. Turley, why are you voting not to impeach President Biden based on this evidence? Where do you think the evidence is lacking? Where does it not rise to the level where you think it needs to be? What are the places that you think is missing?
Well, I said in my testimony that the key here that the committee has to drill down on is whether they can establish a linkage with the influence peddling, which is a form of corruption, and the president, whether he had knowledge, whether he participated, whether he encouraged it.
Now, I agree. That's the link that has to be made. But I thought the question itself was peculiar because isn't the purpose of an inquiry to see where these things go? It's not like they walk in with nothing. They walk in with bank records and text messages and a host of things. That kind of questioning happened a lot. It was Representative Ocasio-Cortez who asked all of the people there who were testifying, do you have any firsthand knowledge of a crime committed by the president? And they all said no. As Stephen Miller wrote on Twitter, he does work at Fox News, did you actually see somebody hand a bag full of money with a big dollar sign on it over to Joe Biden? The question itself seems to be an unwillingness to accept the fact that there's some serious smoke here. What was your take on that exchange?
Yeah, well, that exchange, I didn't watch the entire hearing. I have seen clips and I've seen reports, particularly with regard to Turley. The Democrats are so much better than the Republicans at asking completely irrelevant questions and then somehow acting like they're actually decisive in this case. The question to Turley, and the reason he was there, was whether there was enough to start an inquiry, not to take a vote today. Okay. And so they ask that question, but then they turn it around later and say, aha, and they show clips. Jonathan Turley says there's not enough evidence to impeach. Well, that's not why he was called to testify. This isn't an impeachment vote. This is not an impeachment trial. This is the opening of an inquiry because there's certainly strong circumstantial evidence, maybe more than circumstantial, that Joe Biden was selling influence through his son Hunter, and that this was a family business, and that money that goes to Hunter and other family members is really a benefit to Joe Biden. This was enriching his family. So there's plenty to go on that there's justification to open an impeachment hearing process. But just like, at a trial, you don't say to the jury before the opening statements, do you vote guilty or not guilty? Well, let's hear the evidence, then I'll decide. Okay.
That's exactly it. Let me give you another piece. This was in a 1-2 punch with Alex Wagner on MSNBC. It was Pete Buttigieg, the Secretary of Transportation, and Adam Schiff. Let me start with Congressman Adam Schiff, who, of course, led the charge about the impeachment of Donald Trump, claimed the Russian collusion, said he had evidence of it. And as we have learned, that wasn't the case. Listen.
I think it was a complete debacle. And, and if you'll pardon the expression, it was an ass backwards impeachment proceeding. Historically, what Congress has done when it believed a president was engaged in wrongdoing that might rise to the level of a high crime or misdemeanor is do a thorough investigation. Once you've done the investigation and believe there's a sound basis, then you start an impeachment inquiry. And at the end of that, you bring in the experts to evaluate the evidence you presented and put it in constitutional context. Well, today.
Now, let me ask you a question, sir. You bring in the experts and put it into context. I don't claim to be the expert you are on the Constitution of the United States of America, but I don't recall anything about impeachment requiring a bringing in of the experts. I'm pretty sure it's a political tool where the House impeaches and then the Senate holds a trial. This seems a massive moving of the goalposts.
Of course it is. I mean, this is how they deflect things. They move the goalposts. They insist that Republicans do what they never did with regard to the 2 impeachments of Donald Trump. They all announced he was guilty before they started any inquiry, based on a transcript, I think it was, of a phone call, somebody in Ukraine. So no, the Democrats never do this. And this is, again, why they're so much better than Republicans at this messaging. They just repeat it. MSNBC repeats it. New York Times, Washington Post. Well, they're so much better at deflecting these things. There is a mountain of evidence for which to move forward on a formal impeachment inquiry. And at the end of that, when the evidence has been gathered, they can vote whether to move to an impeachment hearing where they'll take votes.
Would you do me a favor? Would you dig in for a moment on, I mention this on radio all the time, that impeachment is not legal, impeachment is political. While it is a process, it is indeed a political process. You agree or disagree with that statement?
Well, it is a political process. It's set forth in the Constitution. If there is an impeachment trial, which there were for Trump, it would be presided over by the Chief Justice of the Supreme Court. So it's a quasi-judicial process, but the decisions, you do not need experts. You do not need the levels of proof and the legal procedures that take place in a courtroom, because those legal procedures are specific to the court system. They're not specific to the impeachment system. So it is at its core a political process. We'd like to think that you would not impeach somebody and then have a trial without substantial evidence. But I think that with regard to Trump, certainly the first impeachment, very thin evidence that he did anything wrong. In fact, history has probably vindicated him, because what was he asking the Ukrainians about? It's about Joe Biden's corruption. And now we know that there was, okay, whether it was illegal corruption or whether it was just not illegal corruption, influence peddling, which Jonathan Turley referred to, isn't necessarily a crime, depending how you do it. This is, the Democrats have shifted through their media operation the focus of the debate. The debate is not whether there's enough evidence to vote tomorrow to impeach Joe Biden and then put him on trial in the Senate. The question right now is there enough evidence to suggest that it requires further inquiry? And the answer is yes. I think that's so plainly obvious.
That brings us to Secretary Pete Buttigieg. It's almost as if the memo went around, sir. Listen to this.
It's insane. I mean, here we are, something like 50 hours from them shutting down the funds that we use to pay air traffic controllers who make sure that 16 million flights a year take off and land safely. And they're busy with shutdown. They're busy with impeachment they don't even know what for. They just want to have.
They don't even know what for. I was unaware, William Jacobson, legalinsurrection.com, Cornell Law Professor, that Congress can't do two things at once. And the possibility of government shutdown means you don't look into impropriety regarding the president of the United States.
Yeah, well, what he's saying is that because of the possibility of a shutdown, we should shut down now. We should stop doing anything. Okay. So we should do a preemptive shutdown because there's a shutdown that may or may not happen. I think it's probably likely. And of course, we all know when the federal government shuts down, it doesn't really shut down, okay, at all. It continues to operate. There's all sorts of exceptions to that. But that's what they're doing. We can't look into Joe Biden's family corruption and influence peddling because the government might shut down. We'll deal with that when we get to it. But in the meantime, we've got somebody who, by all appearances, sold his office as vice president to benefit his family, maybe to benefit himself. We don't know, but certainly to benefit his family and his son, and sold his position as a likely presidential candidate for this cycle, and for the prior cycle also, to foreign bidders to enrich his family. I mean, it was the evidence of influence peddling by Joe Biden is overwhelming, but I think we need to know more. And Hunter Biden is now gone on offense. He's suing people for blowing the whistle on
suing the IRS. And suing others. And I wonder if people would view it as the evidence on Hunter Biden and a peddling influence operation. That's crystal clear. The question is it crystal clear regarding President Joe Biden? I think that's where people want to make the distinction. I think that's what the inquiry is for. But would you argue for or against, after this day one and what you've seen of it, and certainly the reporting that you've read, should the Republicans keep going, or is this a fool's errand and put an end to it?
No, they've got to keep going. They've started it. Okay, you don't just call it off after day one because MSNBC is upset with you. Okay, and MSNBC is bringing on the same talking heads who say Donald Trump colluded with Russia and it committed treason. They're bringing on the same fools like Adam Schiff to now defend Joe Biden influence peddling for his family benefit. And I think under any corruption statute or any corruption prosecution, if you're engaged in political corruption and the money's going to your wife instead of you, or to your son instead of you, or your family, that's considered a benefit to you. Okay. And I think it's laughable that they would say the Biden clan got mega wealthy by selling Joe Biden's office, but that didn't implicate Joe at all. If he knew about it, then it's corruption.
Just really quick before I let you go, is that the legal standard that if it benefited your son, it could be seen as that benefited you and therefore it's the same?
Well, if it depends on the circumstances, obviously the facts, but if you're selling your office, if you're selling political influence, but you say, hey, wire the money to my son, not to me, because I don't want it trailed to me, you know, and I think that's probably what happened here, is that that message was sent. Don't you dare send money directly to Joe, send it to Hunter. So if you're influence peddling for your family benefit, I think that under most corruption statutes that I've seen, that would qualify.
William Jacobson, Cornell Law Professor, legalinsurrection.com. I always appreciate you taking the time. Always appreciate you being here, sir. Legalinsurrection.com. And my thanks to you for being a part of the show. We're doing a little more longer form. I need to start doing like full hours and stuff like that. It's coming. It's all coming, people. My thanks to Americans for Prosperity, Economic Liberty, Free Speech. That's what it's all about. Find the chapter near you in your state. It is there. AmericansForProsperity.org. Economic Liberty, Free Speech. Appreciate you guys being here. Don't forget to subscribe on Rumble. It's good for you. It builds a character. You'll probably lose weight as well. I don't know if that's true at all, but I appreciate you being here. I'll catch you next time. Take care.